Claimant counsel. Claimant counsel. Mr. Alala. Claimant counsel, announce your appearance, please. He went off. Claimant counsel, announce your appearance. Appearances, please.
Shuaib Kadiri for the defendant. Please, can you hear me?
Yes, I can hear you. I have
Yes.
registered your appearance.
Oh, okay.
I'm waiting for the claimant counsel to announce his appearance.
Maybe he needs to be chatted in case he cannot hear.
He has been, yes, the registrar just spoke to him, but he sent a message to the boss asking when is this matter for judgment starting. I don't know. Anyway, I think I'll go ahead and read the judgment. He's online, so. Okay, this is a judgment between Mr. Phillips Ogwajoe and Gemini Pharmaceuticals Nigeria Limited. By way of a general form of complaint dated the 30th day of August 2023, the claimant commenced this action seeking the following. 1. A declaration that the claimant is entitled to the full payment of the pension sum deducted from his salary by the defendant and the defendant's pension contribution accruable to the claimant with the interest therein, while under the defendant's employment from October 2007 to December 2021. 2. A declaration that the claimant retired as the executive secretary to the chairman of the defendant's company on the 29th December 2021. 3. An order mandating the defendant to pay all retirement benefits and gratuity due to the claimant from July 2021 to 21st of August 2016 on terminal benefit of 1,531,440 for 14 years and 9 months, which amounts to the total sum of 3.909589.6 kobo. Then 4, an order mandating the defendant to pay to the claimant the sum of 3,343.146.90, being the salary arrears unpaid to the claimant by the defendant with monthly interest of 10% from December 2021 until judgment is executed and liquidated. 5, an order mandating and or directing the defendant to remit to the claimant's pension account the unpaid deductions/contributions from 2004 to December 2021 with 2% monthly interest on default payment which remained unpaid to the sum of 3.691.640.4 kobo. 6, an order for the defendant to pay interest at the rate of 10% monthly on the total entitled sum unpaid to the claimant from the day the claimant retired on the 29th of December 2021 until judgment sum is paid and or executed in this matter and the judgment debt liquidated. 7, general damages. An order mandating the defendant to pay the sum of 5 million naira as general damages for hardship suffered by the claimant as a result of unpaid retirement benefits, salaries, and pension since December 2021 till date. 2, an order mandating the defendant to pay the sum of 2,500,000 naira for cost of action and the legal fees paid by the defendant for this action. The claimant's case. The claimant's case is that before his retirement on the 29th of December 2021, he was the executive secretary to the chairman of the defendant. His case is that he was owed salary arrears to the tune of 3.146.90. The claimant asserts that the defendant acknowledged his letter for retirement and promised to pay his pension, salary arrears, and gratuity via a letter dated the 25th day of April 2022. The claimant also states that he worked for the defendant for 20 years and 6 months between 1st of July 2001 and 29th of December 2021, and the defendant failed to respond positively to any of the letters for demand till date. Claimant is yet to receive his retirement benefits, arrears of salaries, part of pension deductions and contribution, and all entitlements due to the claimant upon retirement despite repeated demands through series of letters. Even after the office of the public defender intervened, the defendant made no plans to pay his entitlement. He had to take legal action to recover the total sum with interest from the defendant. The claimant tendered 17 numbered documents that were admitted and marked as Exhibit C. The claimant tendered 24 numbered documents. They were admitted and marked as Exhibit C1 to C24. Many of the exhibits were tendered multiple times. In the body of the judgment, I have all the exhibits marked as Exhibit C1 to C24. Now I go to the defendant's case. The defendant's case is that the claimant voluntarily resigned from the defendant company at age 49, not 60 or 55 years as provided in the handbook. That parties were mistaken as to his manner of exit from the defendant, which was a resignation, not a retirement. That claimant did not give notice of retirement and he was not employed on the 1st of July 2001 as executive secretary to the chairman. That the defendant does not owe him unpaid arrears of salary and parties are negotiating to ascertain the amount owed, if at all. That the defendant did not neglect to respond to letters of demand. Rather, it is the claimant who failed to cooperate at the settlement forum. The defendant's final written address is embodied in the judgment, same as the claimant's written address. I will go straight to resolution of the preliminary issues and the court's decision. Now, the claimant counsel opened its argument with the issue of jurisdiction, which was never raised by both parties in their pleadings. The court, being mindful of the principle heralded by Nikki Toby JSC in Inaloju versus Adeleke, citation provided, that jurisdiction is a radical and crucial question of competence because if the court has no jurisdiction to hear the case, the proceeding will remain a nullity ab initio. However well conducted and brilliantly decided the case might be, as a defect in competence is not intrinsic but rather extrinsic to the entire adjudication. The civil jurisdiction of the NICN is expressly provided for in Section 254C of the Constitution, 3rd Alteration, 2010. This provision clearly stipulates that the jurisdiction shall be to the exclusion of any other court and shall extend to all areas of conceivable labor and employment disputes. From the statement of fact, the claimant is before this court seeking for pension payments, retirement benefits, and salary arrears. Having examined the pleadings / statement of fact, this court is convinced that it has unfettered jurisdiction to hear this suit in view of the relief being sought. Secondly, the learned defense counsel argued that the claimant counsel in his final written address set up a new case bordering on age discrimination, which is unacceptable in law because parties are bound by their pleadings and cannot set up a new case different from the pleadings. The court, having examined the entire pleadings, age discrimination was never raised by the claimant. The position of the law is straight that no matter how brilliant counsel's address is, it can never take the place of pleadings nor evidence. See Bature versus Chidi, citation provided. For learned claimant counsel to raise it in its final written address is overreaching the defendant. Argument canvassed in paragraph 414 to paragraph 416 is hereby discountenanced by the court. The learned defense counsel also argued that the claimant counsel set up new set of facts in his written statement on oath of 30th August 2023 and all the court discountenanced the said paragraph because the writ of summons in bracket statement of fact and pleadings supersede all other processes. The paragraphs in issue were particularly paragraph 4 to 14, paragraph 19, and paragraph 20. The court read through the paragraph and primarily the claimant deposed to the following: that in 2021, the defendant opened a pension account for him, but remittances and interest were not consistent, and interest were not consistently paid until his retirement. 2, that on the 11th of December 2014, the Workers' Union signed an NJIC agreement which can only be amended by the parties. 3, that the defendant issued an internal memo on the 21st of April 2016 to withdraw gratuity. 4, that he gave notice of retirement which was accepted and approved. 5, that 4 months after retirement, claimant is still being owed more than 2 years salary arrears, entitlements, and pension. 6, on the 25th of April 2022, he received a letter with calculations on his entitlement. He replied same day rejecting the calculations and demanding for details of the deduction as well as stating the correct details. And 7, that the claimant has calculated his gratuity based on the NJIC in line with the handbook and calculated his pension based on the Pension Act 204/2014. A scrutiny of the statement of fact revealed that paragraphs 4, 6, 9, 13 pleaded the above facts in the statement of fact and replied to statement of defense. However, paragraph 5 of the witness statement on oath, those facts were never pleaded in the statement of fact. The law is that evidence not emanating from pleadings goes to no issue. See Aweni versus Olorun Kosebi, citation provided. This paragraph alluding to the fact that the Workers' Union signed a NJIC agreement was never pleaded in the statement of fact and is hereby discountenanced. I so hold. Learned Defense Counsel again contended that some documents tendered were not pleaded in either the statement of fact nor the claimant's reply to a statement of defense of March 5th, 2024. These are Exhibit C2, pension statement of account, Exhibit C4, the report of the HRM of the defendant on gratuity. Exhibit C5, defendant's internal memo dated the 21st of April 2016 on withdrawal of payment of gratuity. Exhibit C10, the defendant's reply via email to the claimant, and Exhibit C11, the claimant's reply to the defendant's email dated 20th June 2022. The court observed that Exhibit C2 was tendered in paragraph 4 of the witness statement on its oath. Facts leading to the tendering of Exhibit C4, that the HRM report on gratuity, were pleaded. Exhibit C5, internal memo withdrawing gratuity. Exhibit C10, letter from the HRM detailing details and requesting for reconciliation. And Exhibit C11, claimant's letter to the defendant reconciling calculations on entitlement, were pleaded in paragraphs 9, 10, and 11 of the claimant's reply. In view of the above observation, this court will discountenance this leg of the preliminary objection and examine all the documents in the case file to arrive at the substantive justice of this case. Also, the defense counsel raised objection that 4 exhibits were tendered multiple times. That is Exhibit C2, C22, C23, C24. After a comprehensive reading of the exhibits, the court observed that Exhibit C2, which is the pension statement of account, was later tendered and marked as Exhibit C23 and C24. Exhibit C22, which is the letter from the union, 11th December, dated 11th December 2014, on pension and gratuity, was already marked as Exhibit C3. It is tried that it is not the place of the court to tell counsel how to conduct their cases. In Mosheshe versus General Merchants Limited versus Nigerian Steel Products Limited, citations provided, Anya Gulu JSC, quoting from Strauss versus Strauss, observed as follows, and I quote, "Counsel retained to conduct a case has general authority to decide in his discretion on how to conduct the case. That being the case, tendering same exhibit at trial does not overreach the defendant in any way, and the court will refuse to be distracted with technicalities." Furthermore, learned defense counsel argued that Exhibit C15, the claimant's gratuity calculation, and C17, the claimant's pension calculation, were not signed. Therefore, they are inadmissible to prove a proprietary legal interest based thereon. The cases of Jinado versus Esurumbi Arom and Ashaka Sem PLC versus Mobashurum and Ogunbele versus Oladele, citations all provided. They all confirm that an unsigned document is admissible in evidence, that the issue of lack of signature only goes to the weight to be attached to the document. In the circumstance, Exhibit C15 and C16 are deemed as properly admitted. The court will determine what probative value to attach to it. Then the defense counsel submitted that Exhibit C to the pension statement of account, C16, C17, they fail to meet the requirements of Section 84 of the Evidence Act and should be rejected. This court hereby invokes Section 12 of the NICN Act, and for the interest of substantial justice, the above mentioned exhibit shall be admitted, but the weight attached will be determined in the overall interest of justice. Learned defense counsel submitted that defendants adopt the opposition raised in paragraph 16 and 17 of the statement of defense, and raised the fact that the learned claimant counsel failed to comply with the practice direction 2022 NICN on filing of applications/motions in trade union matters and marking of exhibits. The claimant's processes should therefore be deemed incompetent and the entire suit struck out. On this point, the court, having looked at the witness statement of oath dated 30th April 2023, it reveals that in paragraph 3, paragraph 4, paragraph 5, paragraph 6, 7, 9, 11, 12, 13, 15, 18, 19, and 20 all complied with the practice direction 2022. I so find. Now to the court decision. To resolve the disputing submissions of party, I set a lone issue for determination, which is whether the claimant has proved his case to be entitled to the relief sought. I shall take the relief sought by the claimant seriatim. On the relief sought by the claimant, learned defense counsel submitted, and rightly so, that declaratory reliefs are not granted even on admission. Claimant must succeed on the strength of his own case. The claimant is in court seeking a declaration that he is entitled to the full payment of the pension sum deducted from his salary by the defendant, and the defendant's pension contribution are credible to the claimant with the interest therein while under the defendant's employment from October 2007 to December 2021. The claimant avers that he was an employee of the defendant. In proof of this relationship, claimant tendered the Exhibit C1 a letter of employment stating he was offered an employment as executive secretary to the chairman with effect from 1st of July 2001. This letter is dated 18th day of June 2001. The defendant in paragraph 2 of his statement of defense neither admitted nor denied this fact. And in paragraph 18, further averred that it was opposed to the admissibility of Exhibit C1 because the letter is unknown to the defendant. It does not exist in the HR department of the claimant. Rather, the claimant was employed by a letter dated 27 June 2001 with effect from 1st July 2001. Under cross-examination, claimant admitted that he misplaced the earlier issued letter and the HR gave him another letter. It is clear to the court that the letter of employment Exhibit C1 is not the original letter issued. The defendant has not denied it engaged the services of the claimant with effect from 1st of July 2001. The contents of Exhibit C1 are the same with what defendant tendered as D4. Claimant also tendered Exhibit C19, which is his record of service, and the date of engagement corresponds with Exhibit C1 and Exhibit D4. There is therefore no doubt in the mind of this court that the claimant was indeed engaged by the defendant and there was an employment relationship between both parties, I so find. Having established that the claimant was employed by the defendant, is the claimant qualified for pension as a staff of the defendant? The Pension Reform Act 2014 is one of the laws that regulate pension matters with regards to labor and employment. It outlines the framework for pension schemes and benefits. The Act requires employers to deduct 8% and contribute 10% of an employee's monthly salary to a PFA. Section 5 of the Labor Act borders on deductions, which is a mandatory requirement by law. The claimant in the instant case was described as a registered company with a registered office address in Lagos, Nigeria. Claimant stated in paragraph 9 of his statement of fact that he is yet to receive part of his pension deductions. In proof of this, he tendered Exhibit C2/C24, which is a Stanbic RSC statement for the period 01 January to 2004 to 31st of January 2023. This exhibit is in the name of the claimant with general details and statement summary with a pen number 100076048922. The employer's name is given as Gemini Pharmaceutical Nigeria Limited. The claimant, having proven that he opened a RSA, a retirement savings account with Stanbic IBTC, and the deduction from his monthly salary and counterpart contribution from the employer was not remitted to his PFA, the defendant in his paragraph 10 statement of defense denied in entirety paragraph 14 and paragraph 14 of the statement of fact, which avers that the defendant is owing pension remittances amongst other entitlements. The defendant, however, failed to show proof that it is not indebted to the claimant by way of proof of payments made to the RSA of the claimant. The law puts the obligation to deduct and remit the pension contribution of an employee on the employer. This fact the defendant failed to prove. Mere robust denials are stated in paragraph 10 and 11 of the statement of defense without tendering any proof to substantiate the original, substantiate the denial has not discharged the burden that was shifted to the defendant in this case. By the Pension Reform Act 2014, Section 11 sub 1, it is the duty of the employer to deduct and remit pensions to the pension fund custodian mentioned by the PFA within 7 working days of payment of salary. This is a statutory obligation which carries a penalty for failure to comply. Section 2 provides that an employer who fails to remit within the stipulated time is liable to a penalty of not less than 2% of the contribution per annum. Section 4 provides And Section 103 states that a person who does not comply with the provisions of the law has committed an offense. Section 100 sub 2 compels the defaulting employer to refund all amounts not remitted or misappropriated. Furthermore, in the case of Momudu versus Naimet International Pharmaceuticals PLC, citation provided, it was decided that where such remittance is not done, the total unpaid contribution shall be recoverable as a debt. It is in evidence before this court as shown that the total pension contribution of the claimant is 3.691.640.04 kobo. The defendant did not rebut this claim or that pension contribution was remitted as at when due in compliance with Section 11, Sub 3 of the Pension Reform Act of 2014. This court is therefore convinced that the pension contributions were never deducted and remitted to the RSA of the claimant. This amount has become a debt owed by the defendant to the claimant. The law, as stated in the above cited case, is that this sum must be recovered from the defendant as a debt. This court hereby declares that the claimant is entitled to the full payment of the pension sum deducted from his salary by the defendant, and the defendant's pension contribution accruable to the claimant within the interest therein, while under the defendant's employment from October 2007 to December 2021, Relief 1 succeeds, I so hold. Relief 5 is bettered from Relief 1, seeking an order mandating and or directing the defendant to remit to the claimant's pension account the unpaid pensions / contributions from 2004 to December 2021 with 2% monthly interest on default payment, which remained unpaid to the tune of 3.691.640.04 kobo. In the second stand, the court hereby declares that the claimant is entitled to the full payment of the pension from 2004 to December 2021, and further orders that the defendant makes payment directly to the claimant in the sum of 3.691.640.04 kobo as his pension contribution. Relief 1 and 5 succeeds, I so hold. Relief 2 is for a declaration that the claimant retired as the Chief Executive Secretary to the Chairman on 29 December 2021. From the 2 letters of employment tendered by both parties, Exhibit C1 by the claimant, which the defendant denied was never issued by the defendant, and the claimant admitted during cross-examination that the original copy issued to him was misplaced, and the HR issued another one to him. To the letter of appointment tendered by the defendant as the authentic copy, Exhibit D4, the court observed that both letters appointed the claimant as the Executive Secretary to the Chairman with effect from 01 July 2001. The record of service Exhibit D2/C19 tendered by both the claimant and the defendant also has designation clearly written as Executive Secretary. It is without doubt, therefore, that the claimant was appointed as the Executive Secretary of the Chairman. I so hold. Relief 2 succeeds. Relief 3 is for an order mandating the defendant to pay all retirement benefits and gratuity due from July 2001 to 21st April 2016 on terminal benefit of 1.531.440 for 14 years and 9 months, which amounts to the total sum of 3.909.589.06 kobo. Claimant pleaded in paragraph 9 of the statement of fact that he is yet to receive his retirement benefit, and in paragraph 10, 11, and 14, he pleaded that efforts at the OPD, that's the Office of the Public Defender, and letters of demand by his letters were to no avail. In proof of his entitlement to this relief, claimant in his reply, paragraph 1, stated that due to unpaid salaries for 2 years and unfulfilled promises to pay, and being unable to pay his transportation fare to work, his notice of voluntary retirement was accepted and acknowledged by the defendant, not by mistake, but by mutual proper understanding of the method of his exit from service. He tendered Exhibit C18 and C6. He tendered in proof his letters of retirement, Exhibit C6/C18, acceptance of notice of retirement, Exhibit C17/C19, C18, in paragraph 5 of his reply to the statement of defense, claimant adverted that he voluntarily retired because he voluntarily retired based on a mutual agreement with the defendant after 20 years and 6 months on grounds of non-payment of salary for 2 years, which the defendant did not object and accepted with a promise to pay the arrears. That the rules in the staff handbook, part 3, sub 14, page 28, were overlooked by the defendant, and his notice for retirement was formally accepted because of the defendant's inability to pay salaries as at when due. Again, in paragraph 7 of the claimant's reply, he reiterated this fact that his voluntary retirement was a mutual agreement in acknowledgement of his meritorious service to the defendant. And I quote, the defendant had no option than to accept his retirement notice, overlooking the rules because of their inability to pay his salaries. End of quotation. Claimant argued further that withdrawal of payment of gratuity memo of 21st of April 2016, which is Exhibit C5, cannot be acted on retroactively, and tendered Exhibit C11, which was his response to the defendant's memo withdrawing payment of gratuity. That's Exhibit C5. In the said Exhibit C5, he drew the MD's attention to the fact that by the handbook, page 16, paragraph 6, staff employee who leave the company having completed the minimum required length of service will be paid gratuity for 20 years but less than 25 years in service. An employer was entitled to 6 weeks calculated on total emolument. On the other hand, defendants have argued that since the claimant during cross-examination admitted that the handbook Exhibit D1/C16 and his letter of employment Exhibit D4 form the basis of his contract, the claimant having exited service at age 49, not at 60 years of age, which is the normal retirement, or 45 years voluntary retirement, he is not entitled to gratuity. By a comprehensive reading of the handbook Exhibit C16/D1, specifically page 16, the court noted that the handbook became operational in August 1994, and the caveat for entitlement to gratuity for men under the age of 60 years is, and I quote, unless otherwise specifically agreed. End of quotation. Claimant in paragraph 5 averred, and in paragraph 7, he reiterated in his reply to the statement of the defense that he voluntarily retired based on a mutual agreement with the defendant after 20 years and 6 months on grounds of non-payment of salary for 2 years, which the defendant did not object and accepted with a promise to pay the arrears, and in acknowledgement of his meritorious service to the defendant, and I quote, the defendant had no option than to accept his retirement notice, overlooking the rules because of their inability to pay his salaries. End of quotation. Honorable Justice Kekere Ekun, JCA, now CGN, in Al Rizala Printing and Publishing Company Limited and others versus El Husseini and others, citation provided, held, and I quote, in the interpretation of documents, the golden rule is that when a document is clear and unambiguous, the operative words in it should be given their simple and ordinary grammatical meaning. CUBN versus Sachs, LRCI versus Mohammed, Abalugu versus Shell Nigeria Limited, citations all provided. Claimant is relying on the caveat in the handbook, and I quote, unless otherwise specifically agreed, to argue that the rules were overlooked. That was why his retirement letter was accepted and approved. During cross-examination on the 17th day of October 2024, the learned defense counsel did not avert his mind to this issue. There was no attempt to debunk this averment of the claimant. The law is clear that when a party disputes any averment in the pleading of an adversary, the said party must specifically deny the averment by pleading his version of the matter. Where a matter is pleaded by one party and the other party does not transverse the same, the pleaded matter remains a fact against the other party. Per Mbaba JCA in Bashir Mohammed versus Gidale. Citation provided. In Eyibio versus Mujadadi, citation also provided. Yahaya JCA held, where averments are not denied or controverted in any way, The effect is that there are facts which are deemed admitted, and it is right that what is admitted requires no further proof. See Agbenlero versus Union Bank of Nigeria citation also provided. It is therefore the finding of this court that the claimant's exit was mutually agreed to by the parties and approved by the defendant. Indeed, the defendant agreed to bend the rules and look the other way, which was the condition for a male employee under 60 years to benefit from gratuity. In the circumstance, this court grants an order mandating the defendant to pay all retirement benefits and gratuity due from July 2001 to 21st April 2016 on terminal benefits of 1.531.440 for 14 years and 9 months, which amounts to the total sum of 3.909.589.6 kobo. Relief 3 succeeds, I so hold. Relief 4 is for an order mandating the defendant to pay to the claimant the sum of 3.343.146.90, being the salary arrears unpaid to the claimant by the defendant, with monthly interest of 10% from December 2021 until judgment is executed and liquidated. The claimant in proof of his employment as ES to the chairman tendered Exhibit 1. He also averred that before his retirement, I'll take that again. The claimant in proof of his employment as ES to the chairman tendered Exhibit C1. He also averred that before his retirement on the 29th of December 2021, he was owed unpaid salaries and in the acceptance of notice of retirement Exhibit C7, the defendant promised to pay the salary arrears. Furthermore, the HR in Exhibit C8 acknowledged the outstanding salary to be 3.543.149.90 kobo. The defendant in a statement of defense paragraph 6 averred that it is not indebted to the claimant for any amount of money, if at all, or interest thereon, or at all. The Learned Defense Counsel has argued in addition that the claimant cannot seek for 10% as well as prejudgment interest, since there was no agreement to this between parties in Exhibit D1 and D4 before the court. The court has noted in Exhibit C8 that the defendant acknowledged its indebtedness, and I quote, "Your outstanding salary based on your record is 3.543.146.90 kobo. Furthermore, it stated, and I quote again, the outstanding salary will be paid directly to you based on a payment plan to be decided by the management at an appropriate time," end of quotation. By sections 15 of the Labour Act 204, wages shall become due and payable at the end of each period for which the contract is expressed to subsist. By Exhibit C1, paragraph 3, it provides, and I quote, consolidated salary of 25,000 naira monthly, end of quotation. And by Exhibit D4, the same amount, 25,000 naira per month, is stated as consolidated salary. It is therefore established that his salary was to be paid monthly. It is right that the duty of an employer to pay wages is a fundamental aspect of employment law. Employers are obligated to pay their employees wages in a timely and fair manner, usually as outlined in the contract. In Hinges versus Hopkins citation provided, the court ruled that a contract to pay wages can be implied from the conduct of the parties. It is without much ado that this court is convinced from the evidence tendered that the claimant is entitled to an order mandating the defendant to pay to the claimant the sum of 3.343.149.90 kobo, being the salary arrears. Relief 4 succeeds, but without a monthly interest of 10%. Relief C is for an order for the defendant to pay interest at the rate of 10% monthly on the total entitled sum unpaid to the claimant from the day the claimant retired on the 29th of December 2021 until judgment sum is paid and or executed in this matter, and the judgment debt liquidated. Having read the pleadings and the entire case file, claimant did not state how he arrived at 10% monthly interest, so this Relief 6 fails. Relief 7 is for general damages for 5 million naira as general damages for hardship suffered by the claimant as a result of unpaid and retirement benefits, salaries, and pensions since December 2021. It is right that general damages are awardable per se upon breach, and is compensatory in nature in monetary form as assessed by the court in exercise of its equitable jurisdiction to compensate the injured party by the act of the breach of contract or injury inflicted. The rationale for award of damages is in litigated matter of this kind has been further elucidated. Mrs. Abubakar, citation provided, where the court stated, and I quote, the basic object of award of damages is to compensate the plaintiff for the damage or injury or loss he has suffered as a result of the action of the defendants, premised on the guiding principle of restitution in integnum, that is, putting the plaintiff in a position in which he would have been if he had not suffered the wrong for which he is being compensated. End of quotation. In NACB Limited versus Achagua, citation provided, the court clarified how general damages are determined. Thus, and I quote, one of the characteristics of general damages is that it is fixed by the opinion of the court, such that the law will presume to be the direct, natural, or probable consequence of the act complained of. End of quotation. The claimant established his salaries were owed for about 2 years, which prompted him to retire. In 2022, the defendant in Exhibit C8, after acknowledging its indebtedness at least for pension and unpaid salaries, proposed a payment plan for payment to be decided by the management at an appropriate time, indicating this plan was futuristic and unconfirmed. This case was instituted in 2023 after it was reported to the OPD without success, and so far only 200,000 naira has been paid to the claimant. This court is therefore convinced that the claimant has suffered injury and is entitled to be compensated. Relief 7 succeeds to the extent that this court awards 2 million naira only as general damages. Relief 8 is for an award mandating the defendant to pay the sum of 2,500,000 naira for cost of action and the legal fees paid by the claimant for this action. This relief succeeds to the extent that the cost of action is assessed at 200,000 naira only. Parties are to comply with the judgment of this court within 30 days of this judgment. Judgment is entered accordingly. This is the judgment of the court.
As the court pleases.
As court pleases. My lord, we are indeed very grateful to the court for this well-considered judgment. My lord was very equitable in discharging the judgment, and the spirit within which my lord discharged this judgment is very commendable. My lord, we are most grateful. Thank you, sir.